everyone, I'm Gemma, and today we have Susan, who's our best practice advisor with us, to chat about something really important, terms of business. Now, I don't have any legal training, so I'm coming at this from a consumer perspective. So Susan, why are terms of business so important?
Hi Gemma, it's great to be here. Well, terms of business, which go by other names too, and the name doesn't really matter, is so important because of what they contain. So the terms are the contract between a solicitor and their client, and they are a critical risk management tool. Now, on the one hand, we often see them reading like limitations of the firm's liability, with phrases like reserving the right or we will not be liable for. But on the other hand, and perhaps more importantly, they help to manage expectations for the client. They clarify the relationship, the responsibilities and the rights that both the solicitor and the client have toward each other. And ideally, they should outline what each of them can expect from the other.
That makes total sense. So what exactly do the terms need to cover?
Well, the Law Society of Scotland has some rules about what must be included, and basically they say that the terms should cover the scope of the work being done, and ideally what's not going to be done too. They should specify who will handle the work. Also, they should contain information about the costs, and that includes details about the solicitor's fee and other potential costs. If the work involves legal aid, there are some further details that must be included. The term should also explain how a client can complain to the firm, and lastly, they must include a signpost to the SLCC.
So that sounds pretty straightforward. How well do these work?
Oh, that's a great question. Well, unfortunately, some of the complaints we see show that many clients don't fully understand what the solicitor-client relationship is all about or how it works. So we recently sampled over 80 terms of business to see what was being said, what wasn't, and how it was being said. And we found that while the basic information was generally there, many documents were overcomplicated and confusing and quite frankly not easy to read. We estimated that about 66% of the firms that we sampled had not made best use of their opportunity to effectively manage client expectations.
That's quite a high percentage. So how could these problems have been avoided?
Well, clients who don't understand what to expect can get frustrated, and that's what leads them to complain. And actually that's quite ironic because the terms are supposed to help solicitors avoid complaints. Now, if you're telling your clients as a solicitor why it's important to read the terms, please be kind to them. Please make them readable.
That totally makes sense. You mentioned that there's so much else in the terms that you saw. Can you give me a little bit more detail about that?
Sure. Now, the core information should be what is required by the rules. But there's other guidance and legislation, and that means that generally more details on other points tend to be included, like the client's right to cancel or the requirement for anti-money laundering checks. And it's so easy to get bogged down in the details. But it's also important to think about the context. So when you're writing as a lawyer, there's a temptation to specify every act or section or requirement that you're following. But is that really important to the consumer? Do they need to know which regulation entitles them to cancel or simply that they can do so? So solicitors really need more focus on what's important to the consumer and less jargon.
So how should firms communicate all this then?
Well, in everyday conversation, we don't use terms like the addressee or render invoices or howsoever, or my personal favourite, upon payment of which sum we shall deliver up the document and serve notice thereof. Sure, I bet they didn't try to read that one out loud. Really, plain language is key.
I can't believe someone actually said that.
That's true. When it comes to setting out fees, solicitors also need to think about what is going to be understandable to a client. Now, solicitors for so long have used the term units or sheets, and then they try to explain them. But clients never use those terms in real life. So instead of asking a client to calculate a stated fraction of a unit rate, which is applicable to a junior solicitor for photocopying a sheet, which means so many words, why not just say £1 a page? Also, good layout is important, and that means decent-sized margins and spacing, clear headings and plain numbering. It all helps, and sequencing matters too. Don't scatter information about fees or court fees or when your bill or how much interest you charge across multiple pages. Try to group it all together under one heading like cost of the work. And there's a bonus to that too, because when you try to put things under relevant headings, you might spot something that really didn't belong in the terms in the first place, or could be explained later if and when it does become relevant to the transaction.
So can you give me some examples of how this actually plays out in practice?
Sure. Gemma, let's say that you want to make a will. Okay, you've had a first meeting to discuss your options and now you're getting the terms of business. So what is important to you at this point?
Probably my options. So what's the cost and when I need to pay? Will it be ready for me to sign? And what happens with my signed copy and their signed copy?
Exactly. Now, imagine you've approached a firm that uses a standardized terms of business because we do recognize that it is often easier for them. But their website has claimed they have a personalized approach to every client. So you see that their terms start discussing legal aid or hourly rates for litigation, and even a clause that says when we are instructed by a limited company, or starts to quote Section 6 of the Late Payment of Commercial Debts Act, which I presume you don't really have to hand.
Not really.
So you're probably starting to get a bit frustrated, right?
Definitely. So it sounds like maybe they're just ticking boxes without really thinking about what's relevant to me.
Exactly. And whilst we understand the reasons that firms might prefer to use standardized documents, they could still do more to make them personalized. So it could be something as simple as changing a heading like conveyancing to your purchase of number 6 Aberdeen Way. That can make all the difference. Or tell the client that these are standard terms, but these are the clauses particularly relevant to you when you're making a will.
But surely solicitors want to cover what happens if something unexpected comes up.
That's a very valid point, and we understand that too. Now, conveyancing is actually a very good example because normally this is done for a fixed fee, and normally that fee applies on the assumption that things go smoothly. But the client does need to understand that if complications arise, extra work is needed to get things back on track, and that means an additional fee for the extra work. So, a solicitor can say that. But do they really want to spend 5 pages listing every possibility now?
I'd actually want to skip over that if it wasn't relevant to me. If I didn't have time, especially to wade through it too.
That's exactly right. So maybe the client won't even bother with any of the later pages either. As you say, it's irrelevant to the client until it happens. And when it happens, the solicitor would probably want to have a conversation anyway with the client to assure them that they can fix the situation. And that's exactly the time when the client is going to better recognize the value of the additional fee, which is going to boost their trust.
So what happens when things do go wrong? Like, how should the solicitor handle that?
Well, the terms of business must include information about the client's right to raise complaints to the firm, as well as our contact details at the SLCC. And while some might think that this encourages complaints, a client's right to redress is actually a really fundamental part of any regulated profession, and that's quite apart from the consumer protection principles. And even the most challenging complainers should never face obstacles or penalties for exercising their right to complain. And remember also that firms can still engage with the complainer even after they have approached the SLCC.
So it sounds like the terms of business is a really important tool for solicitors and the complainer. Is there anything else that solicitors might find useful?
Sure, well, a few firms didn't get our name right, and some firms hadn't updated their terms of business to reflect changes like the extension of time limits from 1 to 3 years some time back. We did write to anyone in our sample who needed to correct their terms, but here's another reminder to all others, please, who maybe weren't covered in the sample, to keep your documents current, to review them, to see what you could improve.
So I think it's probably a good thing for us to share the SLCC current details then.
That's right, because since writing the report, we've actually moved to 12 to 13 St Andrew Square, Edinburgh. Now you can find all our updated information on the first page of our website. And while you're there, please do check out our other resources on complaint handling, including our guidance and our blogs. And remember, you can always reach out to us with any questions or topics that you'd like us to cover in future episodes.
Thanks so much, Susan, for all of this valuable information, and thanks to everyone for listening. Don't forget to review your terms of business and make sure they're clear, up to date and client friendly. And if you'd like for further information, remember to go onto our website and follow us on our social media channels. Thanks very much, Susan.
Thank you.